Okay, abusia aye NDC lawyer Edozi Tamakloe aba betutu bi amane aye Ghana Bar Association atanso a expose omo hypocrisy abusia enye asam keto akra na aye Ghana Bar Association demand immediate reversal of aye Chief Justice Torkornoo suspension. Ache se omo pese John Dramani Mahama enimani ya no or revoke a Chief Justice Torkornoo a suspension na or the amano na we NHS NDC lawyer Edozi Tamakloe aba or say into Ghana Bar Association a hypocrisy and answer then abusia and some of the two jano wa babon ordinances in the bo aba I expose Ghana Bar Association enye asam keto Akroma yanko na yenkoti and some of the two ja madam ase.
Bring in just a quick response to that because I want to go back to the GBS position.
I think I entirely side with the concluding statement by my learned friend. Why would you want an impeachment proceeding to drag forever? In order not to create the impression that, like he pointed out, a de facto removal, it's important that the process for the removal is expedited. And so my expectation is that the 5-member committee set to investigate or adjudicate the matters will do that in the shortest, as somebody would say, in the shortest possible time so that it doesn't drag. But more importantly, to the Ghana Bar Association and the statement or resolution
yes,
they offer.
Essentially, they make the point that to the extent that Article 146(10) is a discretionary power, that is not in dispute. Is it therefore in dispute that if it is a discretionary power, it should be governed by Article 296 in its execution?
Now, you see, the Ghana Bar Association is supposed to be a voluntary private association of lawyers, of which I am a member. I think I'm a member in good standing for my last check. Now, having said that, what the Ghana Bar Association, because of its standing, because you see, if you pick the constitution, excuse my language, Ghana Football Association is not mentioned in the constitution, but the Ghana Bar is. Ghana Medical and Dental Council does not have expression in the constitution, but the Ghana Bar does. What it means is that it is a private association that has been exalted to a certain level, and that alone requires sobriety, good conscience, in whatever the bar does. Now, the bar is also, because it's an association of lawyers, when we come out with resolutions, that resolution should accord with law. Because can you imagine association of lawyers advocating for unlawful conduct? Can you imagine the irony of it? That when the association of lawyers met, their resolution is urging a conduct that is unlawful. And why do I say so? The very premise of the resolution is that the president, in exercising his powers under Article 146(10)(a), which had to do with suspension, ought to have published beforehand a constitutional instrument or guidelines to govern the exercise of that power.
Yes.
Clearly, the bar is on a wayward track.
Why do you say
and we should bring them back. You see, this Article 146 has been litigated so many times in our courts.
Yes.
Article 296C has also been litigated.
The same thing.
Incidentally.
The same judge.
Incidentally, if you recall, President Mahama, having remitted the prison sentence of the Muntie 3, Nana Santi Bedie too approached the Supreme Court together with the Deputy Attorney General, the last Deputy AG,
Yes.
Senior Yeboah. And my own senior Eliklim Agbamava went to the Supreme Court saying that the president's powers under Article 72, which enjoins him to pardon or remit a sentence, ought to be done relative to Article 296C. Now listen to what the Supreme Court, the majority of the Supreme Court judges had to say in response to this very colorful, imaginative legal argument. The court said, and this is the court speaking through His Lordship Justice Bennett, he says, quote, however, a decision should not be construed to mean that failure to comply with the provisions of Article 296C attracts no consequence in all cases or situations. Each situation should be examined to determine whether or not the provision is applicable and therefore must be complied with. Now the court now proceeded by saying, quote, having regard to the wild executive powers conferred on the president by the Constitution, it would be literally impossible for him to function if he were to go to Parliament with an instrument to guide him in making discretionary decisions. The court proceeded. Thus, the Constitution has inbuilt mechanisms to guide most presidential actions, whether in consultation with, and I want you to mark that word, whether in consultation with, or on the advice of, or with the approval of, etc. And once the president, now this is very profound, he says that once the president acts in accordance with a particular constitutional mandate, as in the instance, he is not, emphasis, he is not required to comply with Article 296C. This is a decision delivered on 2nd November 2018. Is the bar president, with respect, and the bar, saying that they are not aware of this pronouncement of the Supreme Court? Because this is the Supreme Court, authoritatively. And so, in the wisdom of the framers of the Constitution, you notice that in Article 146(10)(a), it says that the suspension action is not an action taken by the president alone. Can you read it?
Article 146, and we'll put that on the screen.
Article 146(10)(a).
Article 146(10)(a).
Now you know.
We'll pull it out in a bit. And it's essentially in
so if you
acting upon the advice of the Council of State.
It says that the president, when it comes to a decision to suspend, must act in accordance with the advice of the Council of State. Has President Mahama done something contrary? So where from this lawless resolution by the Ghana Bar Association telling the president that having acted in accordance with the advice of the council, you should revoke that? What the Ghana Bar Association is effectively doing is to invite President Mahama to engage in unconstitutional conduct. My question is, why would the bar be the one advocating for such unconstitutional conduct? Because, like the Supreme Court in the Eliklim Agbamava decision versus Attorney General rightly pointed out, he said the Constitution itself has an inbuilt mechanism to check the exercise of discretion by the president. And that in those instances where the president acts on approval, in consultation with, on the advice of, in those circumstances, the Supreme Court said he is not required to comply with Article 296C. Is the bar saying they are not aware of the decision of the Supreme Court? But how embarrassing can it be that the Ghana Bar Association, an association of the creme de la creme, as far as law in Ghana is concerned, can drive itself in such a legal quagmire, why would the bar get involved in this? But you see, the reasoning is simple. Much earlier, the MPP minority in Parliament, led by my senior Bafo, has started poisoning the atmosphere with this legal reasoning that the president, based on Article 14610A, is required to comply with 296C. But like the court rightly pointed out, because this action to suspend is not a presidential decision stand alone, but a decision done on the advice or approval or consultation with a kiosk. So the Supreme Court then proceeded to say that the reason for 296 is to ensure accountability.
I see. To
ensure that so this is what the court said, and I'll read. It's a quote. From the foregoing, the proper exercise of discretion should be marked by fairness and candor. And thus any conduct in the exercise of such discretion, which may be described as being capricious, born out of resentment, or by personal dislike, or fall short of due process, is not proper exercise of discretionary power and constitute abuse of sin. The rationale for Article 296 is to check the abuse of discretionary power.
Yes.
And that is why the court reasoned that the inbuilt mechanism allows for this. Where is the essence of fairness? The essence of fairness is the president is in receipt of petitions. His spokesperson announces that the president is in receipt, and by law, he's supposed to consult the Council of State in a determination of prima facie. Immediately, the Chief Justice became aware. She personally wrote a letter copied to the Association of Judges and Magistrates, and I think the Ghana Bar Association is up. And now ask the president that give me the opportunity to have a say. That's fairness. That's the requirement of hearing.
I see. But
that is not a decision that you can say is tainted by resentment or whatsoever.
But how would you respond, I mean, to the legal positioning that, having admitted, because all across the table we all admit that 14610 gives the president discretionary power to so exercise if he decides, or he may decide to do so. If the president having the power to suspend the Chief Justice is discretionary, how are we going to measure that exercise of that discretionary
so the
power?
answer is in the decision of the Supreme Court. It says, quote, most presidential actions, whether in consultation with or on the advice of or with the approval of. So if you read, the framers of this constitution are very wise people. They anticipated these situations and ensured that when it comes to the suspension of the CJ, the president should not act alone. He should consult. So the Supreme Court is saying in those circumstances, you don't need to go back to 296.
But now, does it answer the question of whether that discretionary power being exercised is done so candidly, fairly?
No, so that is why I answered that question.
And not arbitrary.
If you were listening, and I know, is that I gave an indication that you remember that the Chief Justice had indicated to the president that I want a response. She even said 7 days. The president said, I'll give you 10 days. Gracious. That's procedural fairness. That's procedural fairness. So in this case, the decision that was taken relative to the determination of prima facie is not a standalone decision. I remember vividly when her ladyship Sofa Akuffo determined the prima facie against Charlotte Osei. Charlotte had demanded copies through the presidential, the president.
And then Eugene Ahin responded.
And Eugene Ahin responded and said, at this point, that is not the president's duty to furnish you with copies. 2, after So Akuffo made a determination of prima facie, and I've heard her make the comment that the procedure for removal of CJ is unfair or something.
Oh, she's been talking generally.
No, I'm coming. You see, my point is, she had the best opportunity to call for reform because she made a determination of prima facie against Charlotte Osei. I remember, Malene Senior Tadio was the lawyer for Charlotte Osei. When they appeared before the Justice Anthony Bennett Committee, Justice Anthony Bennett, Mafosa, Agnes Doji, and 2 other people, it was then that Charlotte had the benefit of the petition and who the petitioners were. At the committee level, with her lawyer. It was then that His Lordship Justice Bennett now started putting the procedure to guide their work at the committee level. At that time, her ladyship, Sophia Akuffo, was graciously in that process. I have always said that for a president or whoever to get involved in the removal of another person, it's like Pontius Pilate. It is not a duty anybody wants to perform laughing. It takes a lot of courage to comply with that constitutional dictate. But I've always said, President Mahama has demonstrated consistency indeed. How do I say, why do I say so? If you recall, when the MPP, my MPP brother, Richie Nyama and Frank Anodompre brought the petition for the removal of Vivian Lamptey, Loretta Lamptey, the Shrag boss appointed by President Mills. President Mahama didn't say that the petitioners were NPP ideologues. He received it. And in the case of Loretta Lamptey, President Mahama, after George Nawood CJ made a prima facie determination against her and set up the Niyebua Maria Mowusu Benin Committee, President Mahama suspended her. So, consistent with the conduct of President Mahama is what we are. The Ghana Bar Association felt that as for Shrad boards can be suspended, as for Electoral Commission board can be removed, but a CJ cannot be removed by following the constitutional requirement. How convenient is that submission? Let me conclude on this last one. The bar in the resolution says they are urging the acting, what do we call it, Chief Justice, to immediately revoke the manual assignment of cases.
Yes.
Our bar, the bar I belong, should not become a willing tool for manipulation and demonstrating obvious hypocrisy. Why do I say so? I have with me, Alfred, and maybe later you can project. I have with me a statement or a circular issued by Her Ladyship, now suspended Chief Justice, Gertrude Araba Torkornoo. And this is a circular she issued barely a month after she became the Chief Justice of Ghana. Would you permit me to read?
Go ahead. Yes.
Okay. Just 1 minute. I'm just pulling it up.
And while at it, let me acknowledge our listeners as well on the Voice of London Radio. We understand we're on TV as well there. So
now, now let me read. Circular is dated 28th July 2023. The Ghana Bar Association was in existence or is in existence or whatever then. C distribution. Notice of suspension of electronic case distribution system. Respectfully, I write pursuant to the directive to suspend the electronic case distribution system. I've been directed by the Honorable Lady Chief Justice to inform you that the following supervising authorities are hereby mandated to take over the manual distribution of cases with immediate effect. Greater Accra Region, High Court Complex, Mrs. Patricia Dawson, Court Manager. Then it goes, Ashanti Region, Her Ladyship Justice Angela Mensa Homia. So this thing that the Ghana Bar Association hypocritically is basically edging on the new or the acting CJ was a position that the now suspended CJ in 2023
took. So essentially, it's not new.
No,
in that sense.
Manifest hypocrisy is the bar telling me that in 2023, when this circular came, they were not aware or they were deeply asleep and are just now up. Please, let's be fair.
Okay.
We are building a democracy.
Thank you.
A democracy that should have inherently a semblance of fairness. I'll conclude on this. When President Mahama appointed his Lordship Justice Yao Apao and Justice Puaman to the Supreme Court, the Ghana Bar Association, then led by President NDC, said President Mahama could not have done the appointment the manner in which he did. Why? Because the Judicial Council brought recommendation of 4 and decided to rank them. President Mahama, having received the rank, chose there were 4. So he took 4 and 2nd. Then the bar said, because they have recommended, the Judicial Council had recommended, the president is bound, even if he wanted to choose from 1, 2, 3, or 4. And so he didn't have the right to do 4 and 2. The bar led by NDC went to the Supreme Court to challenge President Mahama. How come that the bar is only up when President Mahama is the one acting?
Because he's more tolerant.
Okay, Abusia, NDC lawyer Edozi Tamakloe, and I just say it's in or fire a Ghana Bar Association and Asam Keto Accra. Chief Justice Torkornoo na NDC for the almost say, dear John Dramani Mahama, he is on the right path, or the Embra and a but I must say, some of J. Penny Cocotisa, Oduwe, and my POG Media, so,